Thank you. You may be seated. We are here today on our case number 1CACV170493, Kopacz versus Banner Health. So, counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if both of you, when you approach the podium, if you would give us your name and the name of your client for the recording. We have read the briefs and we have studied the record in this case. We've also discussed the case in our conference. So with that, Mr. Smith, you can proceed.
I'm Donald Smith, and I represent the appellant, the Kopacz, in this matter, Your Honor. I will reserve 3 minutes at the end. I know it's my responsibility, and I'll answer the court's question, but I'll keep an eye on it. This case is not really a case in dispute of what the law is on the applicability of the statute of limitation and when it starts to run, but how it applies in this case, specifically in the case where a patient, the appellant in this case, is in such a medical condition that she cannot, by her own affidavit and the affidavit of her daughter, is in such a medical state as to be unable to understand what was happening to her post-procedure, and whether that condition that placed her in that is such that she should be allowed to present that evidence to a jury and to determine for them to determine the running of the statute of limitations. The one thing that's interesting in this case is I did notice that the appellees in this case refer to her going back into the hospital. The trial court chose December 28th, without an explanation of why, chose to say that the statute by law, as a matter of law, started to run on December 28th. The appellees pointed out and said, well, she went back into the hospital through the emergency room for a hematoma. The diagnosis that day, on the day she was admitted and the day they did surgery, the actual diagnosis was cardiac shock secondary to internal bleeding, arterial fibrillation, rapid ventricular rate, and acute edema. She had blood loss from bleeding internally, and she ended up having arterial tear that had to be repaired.
Where was that?
That was
the tear.
It was in the. I'll tell you. It's a femoral tear.
Well, see, I understood that to be at the location of the incision.
Yes.
Which, okay.
And then she ended up having sepsis, and she ended up having shock. That isn't. I guess when I think of the word hematoma, I think you fall down, you get a bruise, and you have some bleeding. That's not what this lady was. And it's the two affidavits said that basically for the next several months, she could not understand what was happening to her because she's under acute wound care and infection care, taking multiple levels of painkillers and that stuff. And the affidavit said that she could not understand what had happened to her.
Well, the affidavit doesn't say that, though.
Well, she said she couldn't consider it.
Couldn't consider. Do you think that the statute 12502 applies here? It says that it applies when a person is of unsound mind.
I would believe that would be applicable, Judge, because she could not. Her deposition was never taken. It has not been taken in this case.
Did you raise that, counsel?
That's the
statute.
No, I did not. I argued I did not cite the statute. I argued that she was unable to comprehend what was going on with her, which is her testimony. It will be her testimony. It will be her daughter's testimony. The point of it is that she was so medicated. Judge, one of the things that's in the affidavit, to this day, she doesn't have recall of those events. That's how out of it she was, and that's in her affidavit. That there's times where she's totally blanked out. And when she's going to be asked at her deposition, what do you remember about this? She's going to have to say, I have no recall of that. I don't recall that stretch of care at all. And so she just could not understand. And the appellant's position in this, then it's an issue. I'm not saying that the appellees can't raise this as a defense in front of a jury. I'm just saying that when the appellant's position is it's an issue for the jury. You shouldn't be able to, she should be allowed to stand in front of the jury, or sit in front of the jury, I guess, and say, since we're not doing this in London, she should be able to sit in front of the jury and say, here's what I recall, here's what's my condition. It shouldn't be as a matter of law. There's been some reference in this case, and we see it all the time now from Orem School. Orem School does allow the court to look at the evidence and to consider the evidence. The Orem School does not say the judge becomes the jury. And that's what exactly is happening in this case. The judge has appointed herself the jury and said, this is what I decide. Now, we don't know why she decided that, and we don't know why she based that on the 28th, other than that's the date the appellees recommended.
Well, isn't that the date when your client was in such great pain that the ambulance needed to be called and they took her back to the hospital?
That's the date she goes back.
And she, at that, I mean, she went in for a heart procedure, and
A
originally.
heart complaint. So.
Originally,
yeah.
And she winds up on the 28th with this horrible infected wound in her leg. She
Right.
didn't. I mean, how could she not have known that that was not the proper outcome of the medical procedure that she had undergone earlier in the month?
Well, assuming that for a moment, Judge, that you're correct, that she knows that this is a bad outcome.
Well, taking back, I mean,
Well, but
the ambulance is called, and
well, true, but there are complications that don't mean medical malpractice. That's
what they say.
That's what they say. Well, no, that's what the jury's told.
Okay.
That is a jury instruction, or well, it's not a jury instruction. Every expert, because I do both sides, I do plaintiffs and defense work, and every time I do an expert's deposition and I'm the defense, I say to the doctor, do you agree you could have complications that's not evidence of malpractice? And they all, if they're reasonable, say yes, that's true. So the mere fact that you have a complication doesn't put you on notice. But the point is, Judge, even if you were put on notice that there's a complication, you have to know that would a reasonable person in her position been able to comprehend that and know that and been able to follow up on it?
Are you saying that she didn't know that that was a complication of the original surgery?
By the time she goes in the hospital, Judge, she doesn't know what's wrong with her. That will be her testimony.
Okay, so she has surgery.
Well, it's an arteriogram, but
Okay, well,
I'm going to be fair to the doctor.
all right, that's all right. And the subsequent event happens at the same location that the previous event took place.
Correct.
Right. So, and she didn't know that that was a complication.
But even if she
of the
knows
previous event.
she knows that. I think there's questions for a jury to decide how much she understood what was happening to her because of how sick she was in the next few days. The one point about
Well,
it,
the fact she may have been sick the next few days doesn't mean that at the time she went to the hospital she was incoherent or unable to understand.
I think that
it was a complication.
I think the evidence will be in this case that is the case. That by the time she went, would she have known on maybe the few days before that something's not right and this is not wrong, or not going well? She may have known then. But I think the evidence will be, her testimony will be that from the time that she was taken to the hospital, the emergency room follow-up, but by that time, she was unable to understand what was happening to her and do any kind of research or follow-up on it.
And can you counsel, can you catalog the evidence that is in this record that supports that point that she didn't know what's going on?
The two affidavits would be the first thing I'd send you to, her daughter's affidavit and the affidavit of the appellant herself. Also, the record, if you read the actual records that's cited to you and when cited to the trial court, the medical record, she was extremely ill. She was septic. She was in septic shock, as I understand that definition. She was on heavy pain medications, and that was it. There are, to be fair to the court, there are references that she's oriented times 3, meaning she knows that it's daytime, that who she may be in that. But that doesn't mean she has cognitive ability to understand and pursue what she's got going on.
Did she remain on that pain medication at that static amount throughout what you
All the
claim
way,
to be told?
I'm sorry, Judge. I anticipated your question and tried to answer it before you were done. She was on that pain medication significantly through into her stay at the rehabilitation facility. And it wasn't a rehabilitation such as you're in a car wreck and you go in to get your arm strengthened. It was because of the infection and that stuff and her cardiac condition.
At the same amount, same
It
milligrams?
did start to decrease near the end, but that's why we didn't ask for the extended time. Remember, the only difference here is about 2-week period.
And counsel, are you asking for like a pain medication toll rule?
No, that's not what I'm telling you, Judge. You can have pain medication for the treatment of a sore knee, for example. And you could take aspirin or Advil or something to that effect. Here you're talking about a person who has septic. You're talking about a person who's had cardiac surgery. You're talking about a person who's had major cardiac problems.
But counsel, all of that developed over time. When she first goes back to the hospital on the 28th, she didn't have all of that. She wasn't on pain medicine at that time. She knew at that point in time that there was a complication from the previous procedure, right?
Correct. She knew there was a problem. Whether she's able to understand that that's a complication is an issue, I think.
Don't put her on notice to investigate.
But she's unable to be put on notice, Judge, because by the time she's in the hospital, she goes in on the 27th, and by the 28th, they're doing surgery. We're not talking she goes in the 28th, she lays in the hospital for 2 or 3 weeks. She is sick and in the hospital and incapable of understanding what's going on with her. That's what the affidavit said. This says to comprehend what's understood by her and what's going on. And again, I wanted to make this point again. We're not saying that the statute should be continued for years. We're talking about enough time to allow her to recover and start to understand what was going on. The time we're talking about is about 24 days. So
you are asking for the tolling provision that.
I'm sorry, Judge.
You are asking for the tolling provision that was in the question presented to you.
Yes.
For that 24
but
days.
not just because she's on pain med. I'm going to get back to you, Judge. Not just because she's on pain med, but we're asking for it to be told because of the pain med, the medical conditions, the sepsis, all the illnesses.
Let's take away the pain med. Do you still make the argument?
Yes. Yes.
Just based on the sepsis,
septic shock.
That alone.
That alone should be enough in the treatment of that. How you could treat that at this state without pain med, I don't know. I'd leave that to the people that have MD after their names.
What about just pain med and none of the other?
But when you're in that kind of condition, you are unable to do you're unable to do the investigation. You're unable to do follow-up. If we were asking you, if you took their position, let's say she went in, I'm going to follow up with you, Judge, on this one and try to pull the two together. If you took the appellee's position, if she would have gone into the hospital, and let's say she'd gone in 2 or 3 days before when it first became a wound problem, and she had known that point, but let's say she'd have had thrown a clot and hadn't gone into a coma, and she'd have been in a coma for 2 years. Would mere fact that she might have known something and couldn't follow up on it, would that have been enough to run the statute? And I think the answer is when you can't do the investigation because of the medical condition, when you can't do it, then as a matter of law, it's an issue for the jury. It shouldn't be a matter of law for a judge to rule. It should be an issue for the jury to consider. And that's all we're asking. We're not asking you to rule against them as far as that the statute didn't run. We're asking for it to be allowed to go to a jury for a jury to hear all the evidence. And that's all we're asking.
Is this, there's another statute that sometimes is implicated in a case like this, 12503, tacking of disabilities. And what it says is the period of limitation shall not be extended by the connection of one disability with another, when the law of limitation begins it shall continue to run, notwithstanding a supervening disability. So, I mean, how would that apply here, if at all? Could that apply so that if when she was taken by ambulance to the hospital on the 27th, I thought it was on the 28th, but on the 27th, she had reason to know that she had a bad outcome from the heart procedure, even if she became, after the preceding surgery, in a bad shape, that doesn't matter because she knew for a couple of days. I mean, is that how that statute might apply here?
You could make an argument it would, Judge, but I don't think it does.
Why is that?
Because, let me go back to the first part of the premise, that the mere appearance of a complication does not indicate the need to investigate malpractice. And for example, using some of the cases in hand, the one that was most interesting to me was the wrongful death case in which the statute didn't start to run into the husband gets the medical records. He clearly knew there was a death.
Right.
So how come the death didn't start to running? He got to get the records first. Another case, the dental cases are notorious for this. Dental cases are notorious because the person has a problem afterwards and they don't realize there's been an error for years. The Wall case, I think, is one of the ones, because they do stuff like that. The mere fact that a person has a problem following a procedure does not mean that they should have to start the running of the statute then. And the fact that here is, Judge, that's why I don't think it starts to stack. I think it does. It starts to stack until she's able to understand what's going on.
Sometime in January.
Sometime in January. Right. That would be my position. Judge, I'm down about 4 minutes. If you have any more questions, I'll answer them.
We're good. Thank
you. Thank you, Judge.
Good morning. May it please the court. Rita Bustos, counsel on behalf of defendant appellees Dr. Raj Savajani and his wife Savitri Savajani. I will argue the joint motion on behalf of Dr. Savajani. I'd like to have 15 minutes, preserving 5 minutes for co-counsel Margie Dean, counsel on behalf of Banner Health. In Walk versus Ring, the Arizona Supreme Court noted the statute of limitations protects defendants from stale claims where plaintiffs have slept on their rights. A blamelessly uninformed plaintiff cannot be said to have slept on his rights. Mrs. Kopacz in this case is not a blamelessly uninformed plaintiff. What we do have to understand here is the nature of the claim itself. This is not a standard medical malpractice claim. This is a medical malpractice claim based on a lack of informed consent. A mere complication after the procedure is enough to trigger a medical malpractice claim based on a lack of informed consent. That's because for lack of an informed consent case, what the plaintiff has to show is that, one, there was no informed consent. They weren't informed, for example, that this, in this case, the pseudoaneurysm hematoma was a known complication of the procedure. And then they also have to show that that if they had known that that was a complication of the procedure, they would not have moved forward with the procedure, and then the complication happened. So that's very important in this case to keep in mind. We have undisputed facts in this case. The undisputed facts are that Mrs. Kopacz presented to the Banner Emergency Room on December 20th, 2013. On December 21st, 2013 is when Dr. Savajani evaluated Mrs. Kopacz and ordered the cardiac catheterization and, as the records indicate, had the informed consent conversation with her. On December 23rd, 2013, Mrs. Kopacz underwent the cardiac catheterization performed by Dr. Savajani, where there was actually another informed consent discussion. 4 days later, on December 27th, 2017, Mrs. Kopacz was taken to the hospital via ambulance on her own. She was admitted into the hospital. She was seen by doctors, again, on her own. And what the medical records do...
What do you mean on her own?
She was not accompanied by, for example, well, the records don't indicate that she was accompanied by her daughter, for example, or a medical power of attorney. By all accounts, she was her own decision maker, alert and oriented, able to consent to procedures on her own and explain what was going on with her.
As counsel said, she was oriented times 3.
Yes, exactly. And actually what we do show, if we look at the exhibits to the motion for summary judgment, the original motion for summary judgment, there are medical records attached, which were obviously in front of the trial court. Mrs. Kopacz presented the emergency room on December 27th. She was her own historian. She described her problems to the medical personnel there. She was able to tell them what was going on with her. She was alert and oriented to person, place, time, and situation, which I believe is actually alert and oriented times 4, not times 3. She was able to describe her injury and issues, and she provided a consent to a line placement at that time on December 27th, 2013. And then on also on December 27th, 2013, Exhibit 1D to the original motion for summary judgment, we have a history and physical where a plan of care was discussed with and agreed to by Mrs. Kopacz, including the fact that she had a hematoma, pseudoaneurysm, and may need surgery. That is in the documentation, and it is shown that Mrs. Kopacz was expressed understanding of that issue that she had at that time. And then on December 28th, 2013 is when she underwent the emergency surgical repair of the groin aneurysm and evacuation of the hematoma. That is why the trial court decided that the statute of limitations commenced on December 28th, 2013, because all of the facts and circumstances for Mrs. Kopac's lack of informed consent claim against Dr. Savajani were known and readily available to Mrs. Kopacz. One thing, again, I'd like to point out, as Your Honors have questioned plaintiff's counsel, is for the tolling of the statute of limitations. Plaintiff did not argue that the statute of limitations is tolled, or for tolling in this case. Plaintiff argued for the discovery rule, that she could not have discovered her claim, and they are different. They are different standards, different statutes. There's a statute in this case, ARS 12-502, which was pointed out by Judge Johnson for the tolling. But again, that was not argued by plaintiff, and it's waived. It was not in front of the trial court. It should not be considered by this court.
Let me go back and ask you something about the argument that you make that proceeds from the notion that the claim is an informed consent claim. How would the discovery rule analysis be any different if it were a regular old medical malpractice claim?
Well, Your Honor, in this particular case, I don't believe that the analysis may be that different, because it shows that, well, maybe not, because in that case, then Mrs. Kopacz maybe would believe that, for example, if there was medical negligence, that Dr. Savajani completed the surgery below the standard of care, and then Mrs. Kopacz had this known complication of the procedure, then she would just, in her mind, say, okay, this was a known complication of the procedure, no violation of the standard of care, nothing here, until maybe years later, or maybe she gets the medical records later and she has it reviewed by somebody, or determines that maybe there was a violation of the standard of care. For example, like the Walk versus Ring case. In that particular case, the person undergoing the dental procedures in that case had the TMJ, which was an underlying condition, and then she underwent the restoration, or I think it was a he in that case, underwent the restoration, and then had complications from...
Had no idea why it was hurting.
Exactly, yeah. And they figured that it was from the TMJ. But then in that particular case, come to find out later on that the doctor admitted, I think to an insurance representative, that he violated the standard of care, that he performed the procedures or the restoration negligently. So that's why the court in that case decided, well, Yes, that's when they would have discovered or would have known the facts necessary to bring the medical or their malpractice case in that case.
So your point is that the basis of the informed consent is, or claim is that I did not know I could get a hematoma, and she knew on the 27th or the 28th that she had a hematoma, therefore the knowledge, sufficient knowledge was there as of that date.
Absolutely, Your Honor.
What about the argument that for weeks thereafter, she just felt horrible? I mean, you get fever, sepsis. What about all that? What does that
Well,
do?
Your Honor, and then I would bring the court back to the fact that the discovery rule is a reasonable person standard. It's an objective standard. The core question is when a reasonable person would have been on notice to investigate whether negligent conduct may have caused her injury. The rule does not provide or suggest that a plaintiff must first receive an expert opinion or, in fact, be subjectively aware of her potential cause of action. This was made clear by the court in Little versus State. In that case, it involved the mother of a state university student who died under mysterious circumstances on September 28, 2005. Subsequently, prior to commencing a medical malpractice suit, the mother in that case had, I think it was a journalist who had investigated the case, and they brought a board complaint on July 1st, 2007 against the state physician. And everything, all of the facts and circumstances surrounding the death of her daughter were contained within that board complaint. The board cited the physician for unprofessional conduct on February 7th, 2008. The mother did not send her notice of claim until May of 2008, which was past the statute of limitations and it was past the date that she filed the board complaint where she had done the investigation and she knew the facts and circumstances. And her argument was, well, I was not aware that there was medical negligence or malpractice until the board issued their ruling. And the court said no, applying the objective standard of a reasonable person. They said that based on everything, you knew all of the facts and circumstances once you filed your board complaint. And at least from that time that's when the statute of limitations began to run. And because she filed her suit past that time, it was barred. It was time barred.
Well, let me ask you, you had earlier in your argument said that the tolling argument was waived. What is the difference between that statutory tolling argument and what is the discovery rule argument here? What's different between those two?
And Your Honor, the difference is under ARS 12-502, which is the tolling argument, the statute of limitations is told for if a person is of unsound mind. A person is of unsound mind when he's unable to manage his daily affairs or understand his legal rights and liabilities. This is in the Doe versus Roe case, which examines the tolling under ARS 12-502.
Is there an unsound mind component to the discovery rule?
No, Your Honor, there actually is not. It's two separate but related issues. They do overlap, and what happens many times is plaintiffs will argue for both, that they could not have discovered their claim and that the statute of limitations should be told for unsound mind. Once the statute of limitations defense is raised in a summary judgment motion, it's plaintiff's burden if they want to argue unsound mind, which, again, was not done in this particular case. They have to produce specific facts proving their claim of unsound mind. And this comes directly from the Doe case. The policy of protecting against stale and fraudulent claims cannot be overcome by conclusory averments or such as assertions that one was unable to manage daily affairs or understand legal rights and liabilities.
So counsel, let's say they waived the statutory argument, statutory claim. Then our whole discussion today about unsound mind has no basis in the law?
Well, Your Honor, it does have basis in the law. But
talking to the discovery rule, right? I mean, let's say the discovery rule is a pillar that remains. Is this argument that you can discover something at a later time because of an unsound mind valid in that discovery rule context?
Not not unless it is raised specifically by the plaintiff below in response to a motion for a summary judgment or in response to a statute of limitations argument. It was plaintiff's strategy in this case to only argue the discovery rule and to, in fact, argue that she could not have discovered her injury. And, in fact, I'd like to go back to her affidavit just to read specifically what she claims. She says, at the time I was very ill and I had very little recall of what was going on and could not even consider the possible cause of my medical problems.
Well, in determining when something would or should have been discovered, do we account for the state of mind of the plaintiff?
You can account for the... Not necessarily under the discovery rule, because it is an objective standard. That's very clear. It's whether or not a reasonable person can understand what was going on with them. Reasonable person is a legal term of art. I think that's probably understood by all of us in the legal field. There is actually a case that discusses the reasonable person standard. We did not cite it in the briefs below, so I'm not sure if you want me to give you the reference today. But it does talk about a reasonable person is a fictitious person who conforms to a uniform standard of behavior, the standard of conduct in which the community demands, rather than the individual judgment, good or bad, of the particular actor. It must be, so far as possible, the same for all persons, since the law can have no favorites. So because it is the discovery rule, it says specifically whether or not is when a reasonable person would have been on notice to investigate whether potential negligent conduct caused their injury. And in this particular case, it's very clear. There's nothing for a jury to decide here, facts-wise. All the facts were very clear as of December 28th, 2013, and what the medical records do show was Mrs. Kopacz was alert and oriented. She was able to sign her consent. She was able to discuss her issues with the physicians there. It was discussed with her that she had this pseudoaneurysm hematoma, which may need to have surgery, and actually she did in fact have surgery on December 28th, 2013, and that's why the court decided that the statute started to run on December 28th of 2013. The facts of this case are also similar to the Treed case that we cited in our answering brief, where the individual went to have a dental procedure, and in connection with the oral surgery, the nurse administered IV anesthesia into her hand. At that time, the plaintiff felt pain. She heard the doctor state that that the vein might have been hit. She felt an immediate burning sensation. She began to experience symptoms, but she claimed that she didn't know that she was injured. She didn't know what was going on until I think it was 2 days later when she saw her doctor, and her doctor said, yes, you have this injury. The court said, well, there's no merit to that contention. Treed was aware of the pain in her hand during surgery. She found it swollen and purple at the conclusion of the surgery, and she immediately discussed the problem with the doctor. She was told what the problem was, and then so at that point in time is when she knew that she had the injury. And in that particular case, she only missed the statute by 2 days. But the court still said, we're sorry, but this is the date that you knew or should have known or put on a duty to investigate your potential injury or potential claim of malpractice, and that's the date that the statute began to run. Again, applying the discovery rule in this case, it's undisputed that as of December 27th, 2013, Ms. Kopacz was aware of the complication of the hematoma pseudoaneurysm. She knew it was a complication of the catheterization procedure. And then on December 28th, 2013, she absolutely knew that she had the surgery to repair that hematoma. I'd like to reserve the rest of the time, I'm sorry, to my co-counsel for her argument.
Okay.
Thank you.
Good morning. Margaret Dean on behalf of Banner Health. May it please the Court. I think Ms. Bustos has pretty thoroughly addressed the issues in the brief, but I want to touch on 2 points. One that you made, Judge Johnson, and that is why is this point that this is a informed consent claim significant. And it's significant because if we're looking at the discovery rule, when your sole claim is that it was an informed consent, I was not given informed consent. The moment she has a complication, which she knew of actually before the 27th because she was at home and this is evolving, this hematoma, she knew right then that she had a complication of this procedure. It was in the same location as the femoral artery insertion point. She has swelling there. That's where the hematoma develops. She knows absolutely at that time she's had a complication. So at that moment, her informed consent claim is very apparent to her because that's what we have in the complaint. It's just about informed consent. It's not a claim that there was some malpractice in performing the procedure or anything else. It's just that she didn't have that information to provide informed consent.
So would that argument remain had the plaintiff here raised the statutory tolling?
Well, I mean, again, I think the argument that was made is that the complaint this was a discovery issue, and so
right. I'm saying with the informed consent, that argument that she knew at that very early point.
Right.
Does that statute have any role?
Well, I'm not aware of any medical that in the state of Arizona. There is a recognition by any court of a medical tolling scenario. So the fact that she's claiming in her affidavit that she was then ill and could not contemplate her lawsuit or her claim, there's no recognition for that. That would be a new characterization of a tolling situation in the state that my research has yet to find.
So if you have informed consent, pretty much as a matter of law, you can always determine when that clock starts.
I believe so. I mean, I can't think of a scenario off the top of my head where the moment you have a complication from a procedure and your claim is, I didn't know this could occur, by definition, the moment that occurs, you realize you have discovered your claim. So if this is, in fact, a discovery issue, which is what has been pled and argued to the court below, then absolutely there's no doubt this claim was discovered. Now, the fact that she had subsequent medical issues that arose, I mean, that then does sound like he's trying to make it into a tolling argument, but again, that wasn't pled. And even if it were, the law doesn't recognize a tolling argument for medical care. It's unsound mind, but that wasn't pled here either, and I don't believe she would even meet that standard even if you look at her affidavit. Her affidavit says, well, I couldn't think about it, but it doesn't say that I was of unsound mind. And I do want to point out the medical record, the actual medical record that the trial court had. When she goes into the hospital after this complication arises.
If you could just give us the date of that record, then we'll take it.
You bet. It's December 27th, 2013. It's Exhibit 1C and then 1D. She's documented as being alert and oriented to person, place, time, and situation.
Thank you.
I see that I'm out of time. I'd be happy to answer any questions. Otherwise, I will sit down. Thank you.
Let me address several points they raised, and I'll do it real quickly. One is the dental case that you were cited to by the appellees, the last dental case they referred to you to.
Hand.
Different situation. That person was there, felt the pain, heard the doctor say there was a problem, talked to the doctor, the dentist afterwards, and was told there was a problem, and here's what the problem was. This defendant, this appellee, did not tell her there was a problem during the procedure, did not tell her that he didn't inform her of it, no doctor when she came back said this doctor should have told you this was a complication. Those facts do not even remotely occur in this
Didn't
case.
she know or should have known that this was a complication
That
from the original procedure?
And that leads to my second point, Your Honor. The
I'm here to help.
That leads to the issue of the reasonable person standard. A reasonable person standard is the person in that situation. We're not telling that you should take a 35-year-old female who has no complications and was not this. This is an 87-year-old woman. That's the reasonable person standard you apply. A person in her standard, her position. Could that person have pursued this and understood what was going on? That's one of the problems with people trying to apply the reasonable person standard. They try to apply it to a person who is not in that person's position. not facing those complications, not dealing with those medical problems. A reasonable person in that standard is there. And that,
But
Is there-
oriented, I'm sorry, go ahead.
Is there a case for that proposition?
the case is not off the top of my head. I'll apologize. Yes.
If she's oriented to time, place, situation, what's lacking?
You're right. You're actually
You have an age alignment, anybody over 70, and as I get
That's
closer to
getting
that
real
age
close,
line, I was going to
Judge.
say, I know that's why I was saying tread
But they
lightly.
would probably feel that way about me. I'm just kidding. Actually, Your Honor, you lead to the third point I was going to deal with. There's a difference in being able to say, what time is it? Where are you at? What's wrong with you? I got a sore leg. It's almost 11 o'clock. I'm in the Court of Appeals. It's different.
It did in the medical records. I mean, she did more than just that. She gave the history
Correct.
to the doctor.
She's giving a condition of her play. And when I wrote down, there's a difference, and this is what the jury needs to decide. There's a difference in being able to describe your medical condition at the time and being able to take that to do a legal analysis of whether you have a potential claim that needs to be examined and investigated.
Is your client's complaint solely for lack of informed consent?
That's the claim, yes, Your Honor.
Okay.
If you read the affidavit, it does, both affidavits said that she wasn't told about this, wasn't told this was a potential risk of the procedure, which goes to when it appears, does that put her on notice it's a complication? There is one thing the court has said several times, and I wanted to wrap the last 2 points up very quickly. The court has said several times, well, she saw this and she should have known it was a complication. She wasn't told about it. You have to investigate to know that that's a complication. You have to know, you have to be incapable of doing that. And in her status, she could not do it.
Well, she either knew it was a complication of the original procedure or that it was medical malpractice and it had fallen below the standard.
No, it could just be
She just magically woke up and had a hematoma.
She
at the
could be
same
81
location
years old and you develop problems
around the site.
at the site. Sorry, it could happen. At least that's what defendants tell me, not these defendants. But the point of it is that she couldn't pursue it because of her medical condition. The last point was, my last 13 seconds. Judge, they said to you they want you to reject the discovery rule and go back to the bright line test on this type of case. That's exactly what they told you, because I can't come up with a time it wouldn't be. And this court and the Supreme Court has rejected the bright line test in Arizona. The point of informed consent is to do away with stale cases that damage the defendant's ability to pursue. In this case, there's nothing that shows that this case was stale.
Thank you. Thanks to both sets of lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. Now we're going to recess for a bit to allow the next case to set up.